Committee on Natural Resources will come to order. We are meeting today to once again receive testimony on a bill from my good friend and very valued member of our full committee, the gentleman from American Samoa, Mr. Falnavaga. Then I went and blew his name. Falnavaga. In hopes of making sense out of what is now called the Office of Federal Acknowledgement in the Department of Interior. The gentleman has introduced this bill year after year after year after year. His effort is much like that of the tribes, who wait year after year after year after year for the recognition they so much deserve. But instead, we hear horror stories about the administrative process year after year after year after year. Well, you get the picture. We hear that, first, petitioning tribes are stuck in the system without finality for more than 20 years. We hear tribes must spend huge sums of money, as much as $8 million, to produce the mountains of documentation required by the process. We hear the criteria are too vague and overly subjective. We hear that documentation accepted as proof for one tribe is not accepted for another. And we hear that the system is inherently biased, leaning heavily toward denying recognition. But when the Congress steps in to recognize an Indian tribe, there are those who say we should not. They say this despite the fact that Congress has recognized the overwhelming majority of Indian tribes. They say Congress should stay out to avoid making the process political. I say, if you believe the Interior Department's treatment of Indian tribes is not political, I have some oceanfront property in my home state of West Virginia that I'd like to sell you. To those who say that Congress does not have the expertise to recognize an Indian tribe, I would say look at the record. The record speaks for itself. We've heard Mr. Schuler speak up for the Eastern Band of Cherokee Indians. He knows they are an Indian tribe and they were congressionally recognized through legislation. Do not tell Mr. Keedy, for example, that the Little River Bend of Ottawa Indians is not an actual Indian tribe. They were congressionally recognized. And do not even think of telling Mr. Young, our ranking member, that the Central Council of the Tlingit and Haida do not deserve federal recognition. I would very much like to see us move legislation that will make the administrative federal recognition process fair and manageable. But let me be very clear here that this will not stop me from bringing before the committee legislation to establish a government-to-government relationship with various Indian tribes when appropriate. It is right and it is the responsibility of the Congress to recognize Indian tribes. It is also the responsibility of the Congress to live up to its relationship with the various tribes and provide enough funding to meet our federal obligations. I'm tired of the defamatory attacks claiming that Indian tribes who have submitted applications only want recognition in order to try and open up a casino. I find that charge demeaning beyond words. I cannot even imagine how degrading it must be to know who you are and to know who your ancestors were, but not have the federal government recognize that honorable heritage. The final report of the American Indian Policy Review Commission said back in 1977, and I quote, "The results of non-recognition upon Indian communities and individuals have been devastation," end quote. Coach Kelvin Sampson, a Lumbee Indian, testified before this very committee in April and most succinctly said, "I do not need your permission to call myself Native American, but unfortunately in today's world, I need your validation." Time and again, members of these non-recognized tribes rise up, enlist in the military, and fight for this great nation that will not even recognize them as Indians. I've always found it amazing that those who suffer the greatest poverty and prejudice are so often the first ones to stand up and defend our nation. We have a chance to fix this. I ask everyone here today to help us fix the administrative process. Any phonies will be exposed quite quickly. Let us act now so that no additional generations of Indian children will have to live the indignity of needing validation from the federal government. I now yield to the ranking member, Mr. Cole of Oklahoma.
Thank you very much, Mr. Chairman. If I may, I'm going to read first the statements of the real ranking member, Mr. Young from Alaska. Then I want to offer a couple of comments of my own. Mr. Chairman, let me thank you for holding this hearing on H.R. 2837, introduced by the gentleman from American Samoa, who's been a long and tireless advocate for the rights of Native American people. There were several hearings during the last two Congresses on the issue of reforming the recognition process. When we learned from those, what we learned from those hearings is that it's similar to what I suspect we're going to hear from today's witnesses. The administrative processes at the Department of Interior are replete with delays and backlogs. Also, it's unclear whether or not whether criterion for recognizing the tribes are being applied in a rational, consistent manner. I think we can all agree that reforms to expedite the process and to upgrade fairness, consistency, and transparency are warranted. We should also ask whether or not the department should be authorized by statute to continue a role of recognizing tribes, or whether Congress should handle the recognition petitions. I respectfully suggest that if this committee pursues changes in the recognition process at the department, we should ensure that no tribe seeking a decision on their petitions lose their place in line. Some tribes initially filed letters of intent in the 1970s and have laboriously constructed their documented petitions over many years. While I do not speak to the merits of their petitions, they do deserve a final response before newer entrants are considered. Again, I appreciate your scheduling this hearing, Mr. Chairman. I look forward to hearing from the witnesses. Now, if I may, Mr. Chairman, just quickly add, in drawing for some personal experience, some observations here. Number one, I want to echo Ranking Member Young's appreciation for you holding this. I know I've asked that on many occasions, many members have, because the process that we are engaged in recognition is so complex, so controversial, and frankly has not worked well. And you're very much to be commended for helping us explore that process and figure out the best way to fix it. In the case of my own tribe, the Chickasaws, we know we've been around a long time. DeSoto found us in 1540, and then we ran him out of our territory. So we have a long history of documentation. As a matter of fact, I was back with members of my tribe and an archaeologist and historian 2 weeks ago around Tupelo, Mississippi, just to explore the old tribal sites where we lived before removal. What I think most people don't appreciate is how much the impact of European and then American contact on tribes has scrambled tribes up. In the history of my own tribe, we absorbed the Natchez after the French essentially annihilated the Natchez in the early part of the 18th century before there was a United States of America. Now, the Natchez have also maintained a separate historical consciousness. It's a legitimate question. Are they now Chickasaw, having joined us in a defeat, or do they have an independent existence if they wanted to assert that? And that is just a single example of what's happened again and again and again to tribes. I would actually tell my friends, the wonderful historian Robert Remini wrote a great book, Jackson's Indian Wars. And I remember him handing it to me. He said, I want you to read this book. You're not going to like it very much, but I want you to think about it at the end. Because the thesis basically was, if the tribes, including my own, had not been removed from Mississippi, they would have been destroyed. And that while that was certainly not Jackson's intention to help us, that at the end of the day, removal protected us, saved us, gave us more time, and we were able to survive as a collective force. I read that book, didn't like it a lot because I'd been raised to hate Andrew Jackson. When I was 5, I didn't know who he was, but I knew he was a very bad man and had done terrible things. But after reading the book, I happened to be in Tishomingo, Oklahoma, where my tribe holds every year, and where I will be, frankly, this weekend, a festival, which is our sort of homecoming, and there will be thousands of Chickasaws there from all over the country. And I thought, that might not have happened. Certainly wouldn't have happened in that place if it hadn't been for that process. So there are a lot of interesting things here. And some of my friends in areas where tribes have been, frankly, shattered by European contact think that they've ceased to exist. And in some cases, that's true. I was recently at I went to the Eastern Shore, and just it was a weekend off and enjoyed it. Went traveling around in a boat, you know, one of these tour things where you spend a few bucks and they take you around the Chesapeake, and it was a wonderful tour. And I was listening to the recorded statement. They were describing native presence in the Chesapeake Bay in the 17th and 18th century. And then I heard the most jarring phrase by accident, totally unintended, in a recorded description I'd ever heard. That was until the area had been, quote, detribalized. Now, that's a nice way to say ethnically cleansed. You know, those tribes were shattered. They may or may not have continued to exist. I don't know their history, but it's worth thinking about. So simply because a tribe, we dealt with earlier this year on this committee, Virginia tribes that clearly had been here a long, long time. We're not very large, and in my opinion, frankly, were forced to give up some of their rights to get recognition in the first place, which I thought was unfortunate. But they had maintained a collective identity. They had maintained a real existence. They had figured out that they needed to hide. They were in rather obscure places, and they maintained it. My own tribe had to do this. The federal government, basically, the great Cherokee chief, Will Mankiller, likes to say, if my government had succeeded, I would not be here as a Cherokee. We resisted the ability to destroy us as a country, and that's what happened, or as a nation, to most of the tribes in Oklahoma. So we now, I find it ironic that we find ourselves in many cases opposing people that are trying to reassert an historic identity that they have maintained collectively, and we always tend to question their motives. They're always base. They're always, it's for the money. And that's what, again, many of my friends that don't deal with tribes on a regular basis don't understand. Frankly, tribes are not genealogical societies or fraternal associations. They really do exist to improve the lives of their people, and they've maintained their existence in many cases under the most horrific of circumstances. So I want to thank you, and certainly the gentleman from America Samoa, for putting so much attention onto something that I think is absolutely so critical and part of our history that has not been given the appropriate amount of attention. I really appreciate this committee on many cases having to come in when the bureaucratic functions of the department did not work and do the just thing. Now, I think we would all prefer that we had a process that was more orderly, because it's tough when you're a member and you don't know and you're not from that area to make these decisions. So there ought to be a much better process than we've had. But if there's ever any question about, there's no question, of course, about Congress's right to recognize a tribe. But if we have ever erred in that process, it has been largely because there's been a bureaucratic failure ahead of time. And your efforts and the gentleman from American Samoa's efforts to focus on how we fix it or replace it, if that's the appropriate mechanism, I think, are to be commended. Congress is doing, frankly, what it ought to be doing. So thank you again for holding this hearing, Mr. Chairman.
Chair wishes to thank the gentleman from Oklahoma. We've heard you speak a number of times about the rights and the plights of Native Americans in Indian country. But for this particular gentleman from West Virginia, I must say every time I listen to you, I find it more enlightening and more interesting and learn something. And I appreciate very much your comments. Another true leader on our committee for Native American rights and tribal sovereignty, the gentleman from Michigan, Mr. Keedy, recognize you and thank you for your decades of leadership.
Thank you very much. Thank you very much, Mr. Chairman, and thank you for your great leadership. And whenever I see Tom Cole, I know that this is always a bipartisan obligation, responsibility, which you have served very well, this idea of recognizing the reality of Indian sovereignty. You and I read regularly from the same Constitution, which says, Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes. It does not say and with fraternal organizations, right? And as you say, these are not fraternal organizations, these are sovereignties. And it's in the Constitution, and each one of us up here have taken an oath to uphold this Constitution. And the right of the sovereignty of the tribes is part of that oath. I'd like to thank you, Mr. Chairman, for this brief remark. Thanks for convening this. We know that the federal recognition process is broken. The fact that the current administrative process for federal recognition can take up to 25 years or longer is just unacceptable, and it must be fixed. I'm particularly interested in hearing testimony today from Jim Keedy, a lawyer for the Michigan Indian Legal Services in my home state, who has been working with the Grand River Band of Ottawa Indians. As you know, Mr. Chairman, in 1994, I worked with this committee to reaffirm the status of several Indian tribes in Michigan. At that time, we had 3, and President Clinton signed those 3 bills in the Oval Office. I was going to do a 4th one for the Grand River Band of Ottawas, but the tribe had been so burned by the federal government, they no longer trusted the federal government, and they weren't sure they wanted to be part of any federal process. I mean, they just figured, leave us alone, we know we're Indians, and for God's sakes, why don't you know we're Indians, you know? We signed treaties with them in 1836. Well, one of my greatest tasks and honors was to read those treaties when I first became a member of the state legislature back in 1965. And the state of Michigan recognizes them. Any member of that tribe can go to a public college in Michigan, and the state of Michigan pays the tuition. That was my bill that I introduced. But they decided they'd be kept out of that bill because they have been so burned by the federal government, and that's been the history, unfortunately. Then in 1997, I worked with this committee to pass the Michigan Indian Land Claims Act, an act that provided for the distribution of judgment funds awarded to certain Michigan tribes by the Indians Claims Commission. With the Grand River in mind, knowing that they had great records of their sovereignty, I included a provision in the bill for unrecognized tribes that allowed the BIA to have 7 years in which to reaffirm the tribes if they met certain conditions. I believed that 7 years was more than enough for them to review and make this decision. And that act created the Grand River Indians met all those conditions, and I put in there that a certain amount of that money in that claims would be set aside for a tribe like the Grand River Indians. And time went on, and time went on, and time went on. They applied through the regular process, and it just languished in the regular process. Right now, it's up in one of the higher statuses right now for recognition, but still is stuck. You can even be stuck in the higher statuses. You worked for years to get it up there, but it's still stuck there. And the millions of dollars that I had set aside in 1997 for the Grand River Band went back to the Treasury. That's the history of this government's relationship. The history's been better later, but we still have so much to do, as Mr. Cole and Mr. Ray Hall and Mr. Falamavega and I know. So to realize that the Grand River Band, whose petition is still languishing over there, has actually lost money back to the Treasury because of their, first of all, certitude that they were sovereign people, they were a sovereign nation, and their distrust of the federal government, based upon facts that have taken place, makes it cogent upon us to make sure that we do modernize and bring up to date this system of recognizing these tribes. And at that, Mr. Chairman, I yield back the balance of my time.
Chair thanks the gentleman from Michigan, and now we recognize the sponsor of the bill we're considering today, Mr. Falamavega.
Thank you, Mr. Chairman. I certainly want to thank you for calling this hearing to consider the proposed bill, H.R. 2837, a bill that I introduced, as you said earlier, Mr. Chairman, time after time after time, to provide the process to be mandated by Congress this time on how we should go about recognizing tribes. Mr. Chairman, I was very moved by the gentleman from Oklahoma's statement, and probably the only member of this committee who's Native American, unless if I'm wrong. Certainly I was very moved by the fact that given his own given experience, what Native Americans or Indian country has had to go through, not just to receive recognition, but many other aspects of providing for their needs and their welfare. I've stated time and time again, Mr. Chairman, not to blame the bureaucracy for setting up the recognition process, but the fact that it really comes right back to the Congress. Whether we took action or by omission, which we failed to take action, it just proves that what Mr. Keedy has said earlier. I do want to thank you for all the initiatives and the efforts that you've made in addressing the serious problems dealing with Native American. I think the first policy that Congress or even this government has ever had towards the Indians was to kill them. A good Indian was a dead Indian. It seems to be the policy that we've initiated first. And then it was to assimilate, the process of assimilation. Let's make them all Americans. And then termination. Terminate them as tribes. And so now we find ourselves in the fourth era, or at this point in time, in dealing with Native Americans. We are now have to go through a process of recognizing them as Indians. It's a sad commentary, in my humble opinion, Mr. Chairman, of how we have dealt with the Indian country and members of the Native Americans, whether it be here in Alaska. I think, Mr. Chairman, you have a member of your staff here who is a member of a tribe from Louisiana that's not even recognized. Joshua, where are you? Now, if he doesn't look like an Indian, I don't know what an Indian looks like. But this is how ridiculous the situation has become. And Mr. Chairman, this is not a new issue, as you've said. I think for the last 15 years, ever since I've been a member of this committee, at the time when Governor Richardson was sitting right next to me over there, Bill Richardson from New Mexico, and trying to, hearings after hearings after hearings, how, I should say, terrible the process has been. But the fact that, and I might also want to share this with my colleagues, there is no congressional enactment that provides for the recognition of American Indians. It's all done by administrative authority of the Secretary of the Interior, by regulation. And I remember distinctly the gentleman who wrote the regulations that provided some 7 criteria, the current process, that the Indians have to go through these loops in recognizing. Before they can be recognized, you have to fulfill these 7 criteria that the gentleman who wrote these regulations sat right there and said, you know, if I were to go through the process, even I would have failed in terms of how complicated and how terrible the situation has been in trying to give assistance to the Indians to be recognized. Mr. Chairman, the administrative system for federal recognition of Indian tribes needs reform. Structural and procedural constraints have transformed the federal acknowledgement process into a cumbersome and overly stringent process. I do not need to remind my colleagues of how important the federal acknowledgement process is in Indian country. We all know that for Native Americans to be eligible for federal benefits and services provided by the Department of the Interior and the Indian Health Services, these tribes must be members of federally recognized, to be federally recognized. In addition, federal recognition of Indian tribes opens the door for government-to-government relationships between Indian tribes and the federal government. Most important, this process recognizes Indian tribes as sovereign entities. For these reasons, gaining federal recognition is important in establishing rights and obligations, not only as a prerequisite for many government benefits and privileges, but also as sovereign entities. Mr. Chairman, there are some 565 federally recognized tribes listed. These tribes are recognized as sovereign nations and as a trust responsibility of the Congress, and are eligible to receive benefits from certain federal programs. About 334 petitions have been filed with the Office of Federal Acknowledgement since October of 1978. Of the 334 petitions filed, only 62 have been resolved as of February of this year. 43 petitions were resolved by the Department of the Interior, 9 by the Congress, and 10 by other means. Either they merged with other petitioners or dissolved or just simply withdrew from the acknowledgement process. Mr. Chairman, one thing is clear. For too long, Indian tribes have been denied recognition of their rightful heritage and identity because of cumbersome and restrictive regulations. The amount of paperwork, review, and documentation needed to establish The mandatory 7 criteria for federal acknowledgement of Indian tribes has led to monumental delays in the process. Extremely restrictive academic burdens of proof that exceed even the court's requirements have made it almost impossible to satisfy the demands of the Office of Acknowledgement. Moreover, we have a process that operates on the presumption that many Indian tribes are not legitimate. Essentially, the regulatory nature of the process has grown to impose tremendous burdens of proof on tribal petitioners. Consequently, many legitimate Indian tribes have been denied recognition and being penalized because they fail to adhere to the seemingly impractical standards set for approval. The petitions by Indian tribes for recognition are mired in the process for an average of 15 to 20 years before they are finally reviewed. Mr. Chairman, the evidentiary burden required to meet the mandatory criteria has also imposed a financial burden on many tribes. The cost of compliance has grown increasingly unbearable for many tribes, several of which already live in poor conditions and lack resources or capacity to raise needed revenues. In order to satisfy the requirements, the acknowledgement process, many Indian tribes have sought financial backing to mitigate horrendous financial burdens associated with the process. The results have been disastrous. The great burdens of proof and related information costs have paradoxically thwarted efforts by Indian tribes to achieve federal recognition and retain their sovereignty. Mr. Chairman, because of limited resources and the many benefits of recognition, the process as it is set up has also caused contention and confrontations between recognized tribes and those seeking recognition. Sad, but it's true. Some tribes have even decided to pursue different alternatives. Many have directly sought recognition from Congress. Others have either merged with other petitioners, dissolved, or withdrew from the process. Still others have been involved in litigation because of disagreements between tribes and the Office of Federal Recognition. Mr. Chairman, the bill I have introduced does not seek to remedy all of these problems. My bill proposes or provides much needed reform in the federal process for recognition. The underlying purpose of the bill, hopefully, is to establish a process that will provide accountability, transparency, and helping the tribes to get recognized. This is not a cure-all for the problems we've encountered over the years when tribes sought recognition, Mr. Chairman. However, through legislation, I do believe that it's about time that Congress take action and provide some kind of a structure and a better procedure than the way it's done right now. I am open to any and all suggestions from Indian country, the administration, and my colleagues here in the committee to make whatever changes that are necessary to resolve this problem. Mr. Chairman, I am not going to read the rest of my statement, but I do want to personally not only welcome my good friend, the gentleman from Connecticut, who is here with us, and also the 2 young ladies, beautiful young ladies whom I've dealt with for the last 100 years in dealing with Indian issues. Ms. Patricia Zell, former staff director of the Senate Indian Committee, and also Arlinda Locklear, who's there with us that will be testifying, and I look forward to their statements, and also other members of the panel that will be testifying this morning. Again, Mr. Chairman, thank you so much for finally giving a hearing to this bill that I've introduced 100 times already. Maybe 101 will be all right, but it's time that Congress finally takes action on this, and I sincerely hope that we'll find a solution to this problem that's been gnawing at us for all these years. And I, again, thank you and thank Mr. Cole for your participation and leadership in moving this bill forward. Thank you, Mr. Chairman.
Thank you, Annie. Any other members of the committee wish to make statements? Gentleman from California, Mr. Costa.
Thank you very much, Mr. Chairman. I, too, want to commend you for your efforts to bring this issue to the forefront. I think it's fitting and appropriate that this committee raise the level of review on something that I think has been a problem throughout the country for decades. And I'd like to associate my comments with those that have been made by the gentleman from American Samoa, as well as from the gentleman from Oklahoma, who have spoken with such elegance about the challenges we currently face with Native Americans and the misdeeds that have occurred for centuries by those of us upon those who were here long before the migration to to North America took place. And so it's important that we remember our history. As this legislation, I hope, moves forward, I want to point out two areas that will be, I hope, under consideration. Just from my own experience in California, I believe we have 108 sovereign recognized nations in California, 107 or 108. And we have a significant number that choose to be recognized. I have met with a number of them about the lengthy and difficult process that they have been engaged in with the Bureau of Indian Affairs for recognition purposes. Certainly it's fitting and appropriate when the gentleman from American Samoa talks about the 4 phases, I think, that probably accurately capture what has been faced by Native Americans, at least in the last 2 centuries. And as we embark upon this new phase, hopefully for the better, we can correct some of those misdeeds. But I think I would be frustrated not to mention 2 other factors that I think exist here as it relates to recognition process, which I think needs not only an overhaul, but it needs continuing oversight as this legislation hopefully is enacted. And that is not only as we delisted tribes, but as they consider this process, there is some motivation among the 23 states that have gaming to become recognized because of the potential of becoming a gaming tribe. Now, there's nothing wrong with that. It's legal in those 23 states, but it ought to be put up there under the elements of consideration, because I think one of the other areas that this committee and the Congress has been negligent in is really determining how in the 23 states in which you have full Class 3 gaming, how we go forward prospectively. And obviously that would impact any Native Americans who hope to once again regain their recognition as a tribe, and how we go forward with that. I know we have a number of entities that are actually financing some of these individual Native Americans with the hope through their process that if in fact they become recognized, then they will be a part of their process to establish gaming. And that brings into another issue that I think needs to be looked at, because in a number of the 64 sovereign nations under which, out of the 108 in California, we have an issue, and I don't know how serious it is, but I think it deserves consideration, of delisting that is taking place within those existing tribes. Certainly as a sovereign nation, they have that authority and that ability to do so. But it seems to me that it's an issue that has also been raised, along with the desire to be recognized. So for all the right reasons, I want to commend again the gentleman from American Samoa for his efforts with this legislation. And I hope that we look at the full aspects that are involved in this and related issues, and want to continue to work with all the members of this committee as this legislation goes through the process. So I want to thank you, gentlemen, for your efforts, and pledge to continue to work with all of you.
A gentleman from Rhode Island, Mr. Kennedy.
Thank you, Mr. Chairman. I too want to commend the chairman and particularly the gentleman from American Samoa, and also associate myself with the remarks of the gentleman from Oklahoma who did speak enormously eloquently to this issue. I want to ask those that are going to be testifying to keep in mind, and to the extent they can answer this question in the course of us considering this bill. In my area of the country, many tribes became or settlement tribes. In other words, they made a deal with states in which they were recognized on the assumption that they would be subjected to the state laws, and then they became federally recognized. And then there is this dynamic now as to whether they're which is first. Are they first subject to the initial agreement that they were subjected to by the state under which they were initially recognized as by these settlement agreements, or are they then under the federal IGRA as federally recognized tribes? Clearly, obviously, federal government supersedes state law, and that is the way the Supreme Court has ruled in my case, in the tribe of the Narragansetts in Rhode Island. But that's still being contested, and if we're going to address this issue of tribal recognition, we have to address this issue of this netherworld of tribes in limbo, because as the gentleman from California just pointed out, it's one thing to be recognized, but it's another thing to be treated as a sovereign tribe once you are recognized, and that has to be the bottom line, because you can be recognized, but if you're not treated as a sovereign tribe, then what's the good of it? And I really hope that this is we can nail this down, because I think it's really unfortunate that these tribes, like the one in my state, the Narragansetts, are federally recognized, but they're being denied by the state basically their IGRA rights, and they're the only federally recognized tribe in the country that has been denied those rights. Anyway, with that, I yield back the balance of my time.
Thank you. Chair now recognize our first panel composed of our colleagues. Oh, I'm sorry. I'm sorry, I didn't see you seeking recognition.
Mr. Chairman, it'll just take 2 seconds. I just wanted to make a few comments. I just wanted to thank the chairman for holding this hearing, and I would echo my colleague's statements about the process. I think most of us, the questions really are about the transparency of the process, questions about timing. You know, we had a bill Mr. Schuler was working on, obviously with the recognition of the Lumbee tribe. And as a fairly new member of this committee and a new member of Congress, all of us wrestled with whether or not it is the role of a committee and the Congress to recognize Indian tribes, or whether it is the purview of the BIA to do that. And I think the problem is the fact that it's taking so much time. And will this legislation alleviate that problem? And anyway, I want to commend the gentleman from American Samoa for introducing this legislation. And I think it's very, very important. Questions that I have are about, again, the transparency. Is there a bias at the BIA? Because I would like to take the politics out of the situation, because so many of us, for whatever reason, with each individual tribe, we have our own belief and our own bias towards that tribe and whether they should be recognized. And it's my belief that it should be an independent group, whether the BIA can be independent or whether it's this commission. And not the Congress, frankly. I think it too often gets into to other issues that don't really pertain to those definitions as to what a tribe really is. So again, I want to thank the chairman for holding this hearing and for allowing us to be part of it. Thank you.
Thank you. Chair now recognizes our colleague from Connecticut, Mr. Chris Shays.
Thank you, Chairman Rahal, and to members, and thank you for the opportunity to listen to your statements. It is a true privilege to be here, and I thank the courtesy of the chair and the committee for allowing me to provide a perspective that may be different than what has been discussed from the dais. First, we all want, or we all should want, a balanced and fair process. Second, if the motive is to grant recognition to all petitioners, then I'm simply in the wrong place, because I believe not recognizing legitimate tribes is a true insult. Recognizing a non-legitimate applicant is also a true insult to legitimate Indian tribes. I make the point to you, you are not recognizing Indians. You are recognizing a tribe, a government, and as you know, you are creating an independent, sovereign nation that does not have to pay taxes, can play by its own rules within these United States. So this is truly a solemn obligation. Currently, there are 7 active petitions that are currently being worked on by the BIA, 7. 10 ready and waiting petitions, complete petitions, BIA has not yet begun to work on. So you have 10 people waiting who should not have to wait. You have 79 incomplete petitions, petitions that are lacking all the information the BIA needs to begin work on it. And you have 147 letters of intent, letters informing the BIA of a tribe wishing to file a petition for recognition. In the appropriations process, we provided a measly $1.9 million to the Bureau of Indian Affairs. That's an absurdity. And yet everyone here says we want the process to work better. But you aren't providing the money necessary to have the BIA hire the people to do the research to be current, and yet you blame the BIA. Don't blame the BIA. Don't blame the regulations. I think, speaking frankly, blame ourselves. Just appropriate the dollars necessary to get the BIA to do its work. Now, what the BIA is trying to determine is there social, political, economic continuity pre-colonial times. That's the regulation. Now, if you decide you want to change the regulations and make it a different requirement, you have every right to do that. And maybe you should, as long as it's fair and balanced. I would take issue with the fact that all petitioners want to be federally recognized tribes because of gambling. Conversely, I would take issue with anyone who suggests that some are not making that request because of Indian gaming. So it's a mixture, and you need to sort that out. We have had far more applicants since Indian tribes have had that source of revenue. Out west, it's a modest source of revenue. In where my colleague from Rhode Island and I come from, it's truly a license to print money. And that's why you have a significant financial backing of one tribe in Connecticut, the Golden Hill Pegussets, being funded by a developer who, when the tribe was denied by the BIA, happened to make a contribution of $300,000 to a fundraiser for $300,000 under the previous administration for someone very important in that race, Hillary Clinton, and all of a sudden there was a resurrection by the Department of Interior and re-examining that application. We have another applicant who is being funded by a billionaire. It is because they want to realize the significant benefits of Indian gaming. They are not in this for altruistic reasons for the Indians. That's a fact. They're there to make money. So all of this needs to be part of the record, and I thank you for giving me this opportunity. You may decide that the regulations are not fair. Change the regulations, but why kick it out of the BIA? Just fund them properly. Or you may decide that you want to take it out of the Department of Interior. But in order to determine the legitimacy of each application, because some will be legitimate and some won't be, you need experts. If you are going to depend, and I wrote this down, take the politics out of the process, or, that's what we want to do. I agree with you. Well, the BIA, the professionals aren't the politicians. The politicians are the potential appointees to the Interior Department and the administration itself, whether it's Republican or Democrat. I'm really scared big time with legislation that puts the politics in. And in my judgment, the politics comes in when you take the professionals out. The politics comes in when you don't fund the professionals. So you've got a lot of ways you can go. I'll just summarize. You can properly fund the BIA, and I don't think we'll have the backlog. Or you can set up a separate commission, and I don't inherently have a problem with that. If they're appointed in a way that tries to take the politics out, but has it be based not on a political decision, but can you meet the criteria? And then, as my colleague has pointed out in Nisambula, you could just change the requirements to be what you perceive to be fair and balanced. And I thank you for giving me the opportunity to make this statement to you. I appreciate it a great deal.
The chair thanks the gentleman from Connecticut for his interesting testimony and perspective. And I'm going to yield my time to the gentleman from Oklahoma if he wishes to ask questions.
Just quickly, because I think the gentleman from Connecticut made, as always, very good points. But is it just a funding issue, or, you know, in your opinion, can I just call you Chris? My goodness,
Yes,
I want to say
thank
Mr. Shays. Chris, walk through with me from your standpoint the problems you see other than just funding. Are there other? Is this simply a matter of us writing a check, or do you see things in the process?
I
of the
can't
BIA
get by the
program?
funding because I've spoken to the BIA over a course of many years. The staff is overworked and undermanned, and that's a fact. They have very few people. $1.9 million is all we appropriate for them to go through these applications. When they have 7 active, they have 10 pending. They don't have the people to do it. And yet then we criticize people, the Bureau, for not doing it. They don't have the money.
Let's just say you could write whatever check you wanted.
You'd hire more people.
Well, who would they be? And let me ask you this, too. How long do you think would be a reasonable time? These really are tough issues. I grant you that, because, frankly, the history involved in each tribe is very different. And trying to establish collective identity, when in some cases, frankly, that identity was hidden, because if it wasn't hidden, the tribe wouldn't have been able to continue to exist. I mean, it literally.
Well, then you may want to change the regulations. You may want to say if you're an Indian, you can be granted sovereignty, but you may not be a tribe.
No, I agree with that.
Yeah.
We have no point of disagreement here at all. I'm just asking you, I mean, you've obviously wrestled and thought about this issue. It's pretty easy in a tribe the size of mine. If 42,000 people can establish a continuous collective existence, that's easy. It's tougher with the smaller tribes. I'm just asking
I can answer your question.
What do you, well,
you could put timelines. You could put timelines, provided the timeline begins when the applicant says, this is my completed application, and you could say 2 years, you could say 3, you could say 4 years. You could then make sure that they were properly staffed. Now, what may occur, and what has occurred, is that the tribe starts getting a message that they don't properly meet the standard. And then they back off and pull back their application. Or they may be asked to get information which may take them 2 or 3 years to try to assemble. So it's not all the BIA's fault. It may be that simply there's information that if they acted on that application based on the information, they would deny it. It's not unlike the FDA. You sometimes get the pharmaceutical companies coming into the FDA, and then they have some bad tests, and they pull back their application. Then they blame the FDA for not giving them their, taking too long.
would you, do you still recognize, I would assume, I don't know, I'm asking this question, the legitimacy of congressional action? We still retain, obviously, the ultimate right as the Congress to do the recognition process. Although I think most of us, again, would prefer that be settled before it gets here. But you're not interested in that.
Congress has the inherent right to bypass the BIA and make me a tribe if it wants to. It has that right. It would be pretty stupid. Now, the problem is, when I have to vote on it, what do I know about that tribe? When I'm voting on the House floor, what do I know? Am I going to depend on the elected official in that district who has a political reason as well? Or do I want to depend on professionals who can tell me that they have reached certain standards that we, Congress, have a right to set? So to answer your question, we can set no regulations and recognize them. We can have regulations and ignore them and accept a tribe. But the logical thing to get the politics out of it, in my judgment, is have fair regulations, whatever they are, and then have everybody play by those rules. Maybe once in a while you have an exception. Maybe once in a while, and you then come out to the House floor and say, this is why there's an exception, because there was information that is simply not attainable because they were so obliterated over a course of time. Maybe on those cases you do.
Thank you, Mr. Chairman. Yield back.
Other members wish to ask questions? Mr. Falmavega?
I just want to say to my good friend, Bulavinakavakalevu Sambula.
Amarasa tiko akeva teke iko.
Thank you, Mr. Chairman.
Okay.
That's a little Fijian, sir. As a Peace Corps volunteer, he's the only one I can speak with. And if
Okay, I was
oh,
getting ready
if
to
I said-
respond, but I guess I had the wrong language.
We said you are a magnificent chairman, and we appreciate the good work you're doing.
I knew, I knew I was getting ready to respond.
Mr. Chairman,
Yes, your
the-
time.
my good friend was a former Peace Corps volunteer in the islands of Fiji, and we were just speaking in the Fijian language. So, in case some of our friends don't know where Fiji is, it lies about 600 miles directly south of my islands, which is about 2,300 miles directly south of Hawaii. So, if that gives you a sense, and by all means, I just wanted to share with my colleagues that we're talking about some of the history of why is an American Samoan being the one introducing this legislation. It's interesting to know, Mr. Chairman, that an archaeologist did a DNA study of one of the ancient villages of my island. They call them chicken bones. I guess now they're making studies of chicken bones. Well, they found that these same chicken bones are found in Chile. So some Samoan must have gone over to Chile and ate chicken over there, came back, and I just wanted to share that with you. But I do want to share with Chris's concern. They're very legitimate. It is, and if certainly if in the process that some of these petitioners have motives only for purposes of gaming, then of course they're not to be recognized or even given the time of day.
Could
But-
the gentleman yield?
Yeah,
If they're a legitimate Indian tribe and they also want gambling, then they have every right to want it and deserve it. I want to be on record with that.
I
So
thank the
there's
gentleman for
nothing
that.
wrong with them wanting to have an opportunity to have resources to help their tribe and so on.
I can only cite, Mr. Chairman, the experience that I've had for the last 20 years in hearings after hearings after hearings we had with the Lumbee Indians. And with all due respect to my good friend from North Carolina, Mr. Schuler, unbelievable the testimony that we've had to take from some of the members of this tribe, Mr. Chairman, where they've had to examine their teeth. This is how the administration process. They had to examine their teeth if their teeth look like Indians. And I said, what in the world are we going through? But these are some of the things that are cited. I said, just utterly ridiculous in terms of this is how far-fetched the process has gone in determining what an Indian should be or what he or she looks like. And again, I want to thank my good friend from Connecticut and his concerns, and we'll certainly consider that, members of the committee, and make sure that we do have a legitimate effort moving forward and seeing that the process. Here's what I hope that the process. I think 2 years is not unreasonable compared to the 20 years that some of these tribes have had to endure in seeking recognition. That's basically what I think the process, and not to guarantee also that they become recognized, but that the process becomes transparent. I think more than anything is what we're seeking here. And again, I thank my good friend for his concerns.
Thank you.
Gentleman from Rhode Island, Ms. Keedy.
Yeah, I appreciate your saying that about the legitimacy of tribes being able to do that, because having their own ability to have financial wherewithal if they are legitimate, because that's a good point to make. I mean, there's nothing wrong with having money if they have a legitimate, claim to being. I mean, the Narragansetts, what really where the biggest knock against them is that they was exactly what you said. The Rhode Islanders wanted the tribe to have the casino, but they didn't trust Harrods coming in and financing the deal because they thought Harrods was going to get all the money. That was the bottom line.
Interesting.
And that was what killed the deal for the Narragansetts, ironically. So it was the exact opposite. It was exactly what you were pointing out. If this thing had been all about the Narragansetts being able to get this deal, this thing would have passed, 3-1 for the Narragansetts. It got killed only because the people of Rhode Island felt that there's something asunder, that some corporate gaming folks were going to get the benefit of the deal, not the Narragansetts. So, I appreciate what you're saying. I think it's well-founded. We've just got to make sure that we do make it very transparent and on the up and up so that the tribe ends up being the beneficiary of this.
The chair recognizes members in the order in which they came in, so Mr. Bourne will be next.
Thank you, Mr. Chairman. I'd yield to Heath. He's kind of bigger than I am, but anyway, quick question. Going back to politics. We talked a little bit about this bill, and one of the provisions of the bill that I was reading through, it says that the commission will consist of 3 members appointed by the president. And I can be corrected if I'm wrong, but let's say whether it's Hillary Clinton or George Bush, you can have 3 Democrats, 3 Republicans. Do you think that this commission should be separated between 1 Democrat, 1 Republican, maybe an independent? And being someone who is a bipartisan member of this body, what would be your opinion as to the makeup of this commission if you were drawing up the commission?
First, I would want to have, I might suggest that it be 5, just so that you could have Indian representation from tribes that have been clearly identified for a long time, because I think they will have a sensitivity to respect the legitimacy of the process. I would think that they would have to be Senate approved, and I would think that you would make sure that you do everything possible to insulate them from a political and even financial. I would say, frankly, you would pay them a significant amount of money. Because I can't emphasize, in some parts of the country, when a tribe is recognized, they literally have a license to print money. We're talking about $1 billion a year in some tribes. It's a huge amount of money. Not out west, but out east.
I appreciate that. And going back to the commentary of what actually happens when you have a recognition process through this committee, I would say everyone in this committee has been very thoughtful about whether it be the Lumbee issue or any other issue. But when you get into the full Congress and you have members who frankly aren't as focused on these issues of tribal recognition, I won't say which members, but you hear the conversations on the floor of, they start talking about individual members who are carrying this bill, and, well, I like that person, so I guess I'll go with that tribe. That's literally how these decisions are being made, and that's the wrong way that they should be made. They should really be made by people who understand the process and understand what it really means to be a sovereign nation. And so I appreciate you coming and testifying before the committee. Thank you.
Gentleman from North Carolina, Mr. Schuler.
Mr. Chairman, thank you. I just want to clear up, in all due respect, by this Congress, the reason the Lumbees have never gone through the recognition process is because it's what's happened. The Congress actually stopped that recognition process. It wasn't the BIA, it was the body of Congress. And if we're going to have that, and I guess the hard, I don't know, growing up in the mountains, I mean, math is pretty, it's a basic education process. If you got 3 people trying to make a decision versus an entire organization, I just don't know how you're going to increase that backlog and get it a lot faster through the process. 3 people making a decision of all the work and the research that needs to be done.
No, if I could, they would have to have a sizable staff, far more than I envision that you basically take the BIA folks who do recognition and you move them under this commission. Whether they're directly in or still under the Department of Interior, they would have to provide extensive data to this commission.
Well, that's what I would hope. I mean, you're really, we have to take the politics out of it, without a doubt, and I commend you for your work. And my friend from Oklahoma, Mr. Bourne, we do. I mean, we're all caught in the middle of it in so many different ways. We understand the processes, but outside of this committee, our members outside this committee don't understand the process and the problems that we've had to deal with and what has happened in the history of our country. And so I commend everyone for their hard work and their dedication, just finding putting the right information together that we can do the right thing this time and allow people to go through the process. That's why I offered my amendment for the Lumbees to actually go through the process and have that opportunity to be recognized if so. So, Mr. Chairman, I yield back.
Chair thanks the gentleman from North Carolina. Any other members wish to be recognized? If not, Chris, thank you.
Thank you again
Thank you for your
this
time and
opportunity.
patience.
Thank you for your
testimony.
patience.
Our next panel is composed of the Honorable Carl J. Artman, the Assistant Secretary for Indian Affairs, Bureau of Indian Affairs, Washington, D.C. Mr. Secretary, we welcome you. Thank you for your patience with us this morning, and you may proceed as you desire. We do have your written testimony, and without objection will be made part of the record as if actually read, and you may proceed.
Good morning, Mr. Chairman and members of the committee, and thank you for holding this hearing today. As you stated, I do wish to submit the full statement for the record, but I will make some short comments regarding this hearing, the subject of this hearing. My name is Carl Artman. I'm the Assistant Secretary for Indian Affairs at the Department of the Interior. And to my right is Lee Fleming, the Director of the Office of Federal Acknowledgement. Thank you for the opportunity to present our views on H.R. 2837, the Indian Tribal Federal Recognition Administrative Procedures Act. The Department supports the efforts to improve the acknowledgement process and is, in fact, taking steps on its own accord to improve the process. However, the Department does not support the current bill as written. The federal acknowledgement process may need reform. However, this legislative approval doesn't address at least 6 provisions that we would view necessary if Congress wishes to legislate criteria for acknowledgement. And these necessary provisions would include the definition in the process as to how the petition will be reviewed. Provide detailed standards of proof, as in 83.6D and E of the 25 CFR, which mandates that a reasonable likelihood standard of proof be used. Clarify the Privacy Act protections and Freedom of Information Act exemptions. Provide guidance as to how to address the splintering of petition groups and the subsequent submission of letters of intent and documented petitions by factions of petitioning groups. Provide clarifications on the sunset rule and provide the definition of the administrative record for purposes of judicial review. This legislative proposal replaces the secretarial decision-making authority with a decision-making body prone to political influence. The legislation does not provide criteria to ensure the appointed commission members have the requisite ability or minimum skill set to make determinations on individual applications. It doesn't address the institutional knowledge of the Department of the Interior on these matters and lowers the bar for acknowledgement by requiring a showing of continued tribal existence only from 1900 to present, rather than from the first sustained contact with Europeans, as is in the current standard. The Department does, however, support congressional affirmation of the Department's authority and give clear congressional direction as to what the criteria should be. Congressional ratification of the acknowledgement standards would speed up the process because the Department would no longer have to spend time and resources defending and preparing for litigation, challenging its authority to acknowledge tribes or the specific criteria used to do so. Courts have upheld the Secretary's authority in this area, and congressional support would preclude further challenges. The federal acknowledgement process set forth in 25 CFR Part 83 procedures establishing that an American Indian group exists as an Indian tribe allows for uniform and rigorous review necessary to make informed decisions on whether to acknowledge a petitioner's government-to-government relationship with the United States. The regulations require groups to establish that they have had a substantially continuous tribal existence and have functioned as an autonomous entity throughout history until the present. A petitioning group must demonstrate that they meet 7 mandatory criteria with a reasonable likelihood of the validity of the facts relating to that criteria. We're considering several actions to expedite and clarify the federal acknowledgement process and anticipate that these clarifications would eliminate many of the backlogs and delays that have been discussed this morning. Among the proposed improvements that are in the written testimony are technological improvements to the process, the possibility of moving applications to the front of the ready and waiting for active consideration list, and streamlining various OFA processes. We're also considering various ideas for improving the federal acknowledgement process by amending regulations. These improvements would help to process and complete all applications within a set time frame. These include hiring or contracting additional staff, establishing a timeline for responding to each step of the regulations to ensure that the petitions move along, issuing negative proposed findings or final determinations based on a single criterion, allowing for an expedited negative proposed finding if the petitioner has failed to adequately respond to a technical assistance review letter or refuses to submit additional required materials in response to this review, and moving the first sustained contact requirement of 25 CFR 83.7 B and C for some cases to start at the point when that area became part of the United States or to 1776 to ease the burden on the petitioners and reduce the time-consuming research into the colonial histories. The acknowledgement of continued existence of another sovereign entity is one of the most solemn and important responsibilities delegated to the Secretary of the Interior. Federal acknowledgement enables that sovereign entity to participate in federal programs for Indian tribe and acknowledges a government-to-government relationship between an Indian tribe and the United States. It confers unique privileges and immunities upon that government and may yield substantial financial support from the federal government for the operation of that tribe's government services. Any opportunity to alter the existing legislative or administrative options available to petitioning groups must uphold this solemn responsibility with well-informed and durable processes that anticipates the needs of all stakeholders. Thank you, Mr. Chairman, Committee, for the opportunity to provide my statement on the federal acknowledgement process, and I'll be happy to answer any questions that the committee may have.
Before proceeding, the chair wants to welcome to our full committee today the gentleman from Louisiana, Mr. Charlie Mélenchon. Without objection, I'd like for him to be allowed to sit at the dais and participate in the hearings. We welcome you, Charlie. Mr. Artman, you testified that the Department of Justice, and I quote, has indicated there are constitutional concerns with the appointment of members of the commission, end quote, in H.R. 2837. Now, I realize these are probably not your words, but the committee takes the Constitution very seriously, as the gentleman from Michigan, Mr. Keedy, is so prone to point out. And I find it odd that the Department of Justice would indicate such a thing without explaining in detail the problem. So my question is, can you enlighten the committee on this potential problem?
Chairman Rahal, in my discussions with the Department of Justice, they're still developing that statement, and I'd be happy to get that to you when it's complete. As has happened before in this committee and with the Department of Justice, the Department of Justice does weigh in on these constitutional matters, and we've seen it before, and even legislation with the Hawaii recognition bill as well.
Like OMB likes to weigh in on budgetary matters.
As would be expected.
We appreciate that. Thank you. We do appreciate your getting that information to us at a later time.
Chairman?
Yes.
You yield?
Be glad to yield, Chairman White. Yeah.
I'm not quite sure what you meant. You brought up the Native Hawaiian bill. What did you mean?
Well, just that the Department of Justice has weighed in on the constitutionality of that as well. This isn't
you said it was developing something.
I'm sorry?
Is that, but you referenced that. That's been going on for years.
Yes, I only reference it as a practice, Mr. Abercrombie.
Isn't that then just a commentary, somewhat enlightening commentary on the necessity of this bill? Is the Department of Justice so bereft of capacity to come to make decisions that it would take years to do this?
No, but they were looking at this particular bill, sir.
What's taking them so long?
I don't know, sir.
Well, do you think it's a good idea to have something take so long?
Well, if you're talking about the Department of Justice review, I don't want to put myself in the shoes of the department for answering that question. They have their processes for doing these things.
You referenced them, though.
Yes, I did.
You think there should be a time certain? Doesn't this bill call for time certain decision making?
Well, in the acknowledgement process, yes, it does. But I think what we're talking about here, Mr. Abercrombie, is the Department of Justice's review of this particular legislation and the constitutionality of the commission appointment.
How long do you think that's going to take?
I don't know.
Should we postpone making a decision on this bill until the Department of Justice decides that we can move forward legislatively?
That is not something that I can speak to, sir. That's within the your control, sir.
Thank you.
Mm-hmm. Chair, thanks the gentleman from Hawaii. Mr. Secretary, you've testified that you plan to distribute revised guidelines so the petitioners involved will know what is expected of them. How were these revised guidelines put together? And did the department consult with the petitioners, Indian tribes, or other interested parties?
The proposed guidelines, and let me just run through what some of those proposed improvements might include. There's a plethora of them, and we hope to have a final document that we can review and share with people in a number of weeks. But some of the issues that we would address are developing a policy for addressing splintered groups. Right now, in many of the petitioners that are in the 17 that were mentioned earlier, there have been a number of splinters in the groups, and you've essentially created additional tribes in that same process seeking the same recognition using the same record. And we don't have a policy for dealing with that. We're looking at potentially coming up with new forms to both deal with the application process, so there's a consistency in the information, as well as submitting the genealogical information on a consistent form and in a consistent method. Also staging reviews and looking at moving up petitioners on the ready list if they've been living on a state reservation for 100 years or if they have voted for the Indian Reorganization Act in 1934. Limiting the technical assistance reviews so as to speed up the process and bring some finality to the stage. More concise decision documents. Expedited negatives, both under the criteria and if there's no response to the technical assistance letters. In looking at whether or not and how we roll these out, I brought these up. I've brought them up in forums such as this and in other speeches, and have invited people to participate. When looking at the consultation process, the question becomes, with whom do you consult? Right now, the executive order on consultation looks at federally acknowledged tribes, but we're dealing with petitioners. We could consult with federally acknowledged tribes, but then who are the tribes that are impacted by that? These are things that we're going to be reviewing in the upcoming weeks when we have a final document that we can work with.
So as of yet, you have not consulted with the Indian tribes or the petitioners?
We have not consulted with any of the federally acknowledged tribes. No, we have not.
The Chairman,
okay. Yes, how you?
A quick question to Mr. Secretary. For 29 years, how many times have you made revisions of these regulations?
We had the revisions in 1994.
That's the only time that you made revisions?
That's most the largest amount of revisions were in 1994.
It seems that from what I hear from you, Mr. Secretary, man, it's a whole revamping of the process, of just the regulatory process itself that you just shared with the committee this morning. And my question is that it sounds like you constantly are making revisions of the process, and this is what I'm a little concerned about.
No, and I understand your concern, sir, and that this may be a moving target, that the petitioners may not understand what they have to adhere to, but that isn't the case. And we're going to be dividing up any changes we make into regulatory and guidelines, and there are even some that we've developed that may require legislative action. What we're going to be coming out with in a number of weeks is going to be guidelines. That's going to be affecting the process under which the current regulations currently oversee.
Did it just so happens that the revision process coincided with the proposal of the bill, or
no?
This has been in planning for the last 6 years?
This has been in planning since about March 6th of this year.
Of this year, but
yes.
Not the previous 6 years?
No.
Okay. Thank you, Mr. Chairman.
Mr. Cole.
Thank you very much, Mr. Chairman. Mr. Secretary, good to see you, and thanks for all you do, and a good friend and a wonderful background. I've got a series of very specific questions, and then, frankly, I wanted you to talk a little bit more about splinter groups, because I think this is a real challenging area. Number one, Mr. Shays suggested this, if we just got you the resources, you can do the job. So in your professional opinion, is this primarily just we haven't appropriated enough money for you to handle complex and difficult issues in a quick and timely manner?
I think we're dealing with two issues here. One is the resources. Right now we have 4 teams looking at 17 active petitions. And if you have those 4 teams going through their normal process, that will take about 4 years each. So you're looking at quite a bit of time to get through those. It's about 5 years to get through all 17. with additional money, we could hire more teams. When the GAO did a report, an investigation, a report on this recently, they found that it takes on average 8.3 years for the petitioning tribes to get through. But that's a bilateral process. That's also with the tribes submitting the information, having a complete application as well. It should be taking us on average about 4.7 years to get through this process. With additional staff, we can meet that average, certainly. But I think that we can also achieve expeditious review with greater efficiency. And that's what we're aiming at when looking at these, at revising guidelines, potentially looking at new regulations and also potential legislation.
Let me, if I may, ask you your professional opinion on the wisdom of timelines or literally drop-dead dates along the way, because I think that's part of the huge frustration is that people seem to go into a bureaucratic situation and just simply get lost for whatever reason. And there just seems to be no point at which a decision has to come. You know, would it be wise, in your opinion, either at the departmental level or the congressional level, for us to mandate that these cases be disposed in a certain period of time?
I think at any level, timelines are going to be beneficial to the process. There are situations in our history where, you know, it was just brought up earlier, a reference to applications spending 25 years in the process. And in those situations, you know, one in particular that I'm thinking of, a letter was submitted in 1978, I believe, and then a response, a technical review response was sent back to the petitioner. And there was no response for 5 years. And there are these blank spaces in the process that accounts for that 25 years, but there's nothing that we can do about it. We can't reach in and say, give us the information. So timelines, I think, have to go both ways. Timelines both on the petitioner and also for the department, and that's something certainly we're looking at and something we would support.
I'm going to skip ahead and ask you another question then. On the approval process, let's say, I mean, do you have, again, a professional opinion on, let's say you come up at the departmental level with a decision. Frankly, Congress has the ultimate authority. What is an appropriate, if any, appeal process?
Well, right now, the appeal process goes through the administrative process, the IBIA, and then into the federal courts. That seems to have worked. We do spend a lot of time questioning our ability to actually go through the acknowledgement process. But for the tribes that have gone into the process, well, I'm sure that the ones that have not had a success at the end of the appeals process may disagree with this comment, but it seems to have worked.
So the process, the problem seems to have been in the initial decision making, but you think once a decision's made, it's moved pretty well?
Yes.
Okay. Let me ask you this, because I do want to get to the splinter issue, because this whole question of tribes at European contact is a really interesting question. And I want to give you not a hypothetical, but reality. What do you do? Let's take two recognized tribes that were one at the point of European contact, the Eastern Band of Cherokees and the Cherokees in Oklahoma. Or let's take the Mississippi Choctaws and the Choctaws in Oklahoma. Or let's take the Seminoles in Florida and the Seminoles in Oklahoma. Those were tribes that American activity, you know, split asunder, forced removal and what have you. So how could you possibly, if you have to go all the way back to European contact, and in the end, now they didn't lose, you know, we recognize all these entities now as having maintained a collective identity. So this whole idea that tribes have to have existed in 1540 or 1680, when we took actions, they did not lose their corporate identity, but we split them asunder, that seems to me a contradiction. Can you, I mean, how are you going to handle things like that when you talk about, quote, splinter groups? Because that's part of their historical reality. They became a tribe or continued to function in a tribal way, even though they had lost, you know, their homeland in one case, or had stayed, you know, retreating into the mountains in the Carolinas, for instance.
I think the groups that enter the petition, that have a splinter prior to the petitioning process, or are there because they splintered off from a different tribe, such as with the Cherokee, and we have quite a few, probably about a dozen different groups that claim to be of Cherokee descent. Those are a separate issue. Let me just address the European contact question and then focus on the splintering issue. The European contact question, I think you raise a very valid point. How do you establish what happened in the pre-colonial era, in the 1500s, 1600s? And that's why we're looking at moving up that date to first contact, or when first contact after a region became a state, or in 1776. So there's a cutoff date, and we're saying we're not going to go prior to that. with splinter groups, what is causing issues for, the biggest issues for us, is not those groups that splintered prior to it or there was a historical splinter. Those we can deal with through the normal process and the normal rules. What becomes, if you have petitioners who are tribes that are seeking the federal recognition, but they are acting as governments, you have those problems that oftentimes come with governments, especially the more local you get, of electoral disputes. Right now, we've got a number of tribes that are federally recognized and they're having electoral disputes. There's no reason to think that petitioners wouldn't have the same problem with their government, and that's what we're seeing. We're seeing groups, there was one group in particular recently that has split into two, and then that one, those two groups split into two as well, and each one wanted to have and maintain its own place on the list and not be subjected to additional review. They wanted to have each other's information. And the question becomes, what do we do then with that? That isn't so much a question of recognition of a historical stance or a historical position, but now that's a political question of who is actually in control of the situation. And while we look at one of the criteria is political control, these things happen, and it's almost a positive action that this has occurred, because you do have an active and mature government fighting for control, vying for control of that one entity. But in the petitioning process, it's viewed more as a splintering, and now we have 2, 3, sometimes 4 groups that are all vying for that same spot. In that, we have oftentimes counseled with those folks, worked with those folks, and tried to deal with them, but it becomes too difficult. Now it looks like we're beginning to insert ourselves into that political process. We don't insert ourselves into the political process of federally recognized tribes. We shouldn't be inserting ourselves into the process of petitioners either. It's almost paternalism gone bad. So we're trying to figure out a way to handle those. And right now, one of the potential ways of handling those that we're looking at is pulling them out of the entire process and putting them off into a neutral area while they figure out what's going on. And when they're done, and they say that they're done, we can bring them back in where they were before.
Thank you, Mr. Secretary. Thank you, Mr. Chairman.
Thank you.
Gentleman from Michigan, Mr. Keedy.
Thank you, Mr. Chairman. Just a point. I know there's a vast difference here. My analogy is not that good, but you know, it took us a matter of a week or two to recognize the Republic of the Ukraine, Republic of Georgia, Azerbaijan, Armenia. We worked much more quickly once it was decided that the Federated States of Micronesia wanted to become an independent country, Republic of Palau, the Republic of the Marshall Islands. But when it comes to our own people here, I recognize the differences, and I will accept those differences, and they are vast. But maybe we can learn some things from the State Department. They seem to be able to, you know, recognize sovereignty much more quickly than we are in the Interior Department. I say that because I personally have been in contact with the Grand River band for 42 years. No question, they're sovereigns. I mean, they're a nation, and yet they took them 11 years for them to get in the ready for active consideration. The next step would be active consideration, and the next step would be recognition or denial. They've been 11 years, took them 11 years to get in that ready for active consideration. They've been in there since the beginning of this year. How long do you expect, what would the ordinary time be for them to get into the next step, assuming that they're moving in the right direction, into active consideration? What's the average length of time they stay in that ready for active consideration?
The average length of time from start to finish should be about 4.7 years. From the submission of the letter of intent to the final determination, be it positive or negative, should be about 4.7 years. As I mentioned earlier, the average is turning out to be about 8.3 years, as the GAO found. But again, we're looking at two issues that are creating delays. One, it's a bilateral process. It starts off with the petitioner sending in a letter of intent, and we send a response. The 4.7 years is best achieved when both sides are submitting information back and forth on a regular basis. But we do have periods where there's no communication between the parties for years at a time. And that can turn into 5 years, 10 years, and then now, like I said, we have groups that have been out there for 25 years. Time alone on the list doesn't make it right or wrong as to whether or not they should achieve that recognition. We have 7 criteria, and if the 7 criteria aren't right, if that's not what we should be using, then we certainly look to Congress to tell us what those correct criteria are, or perhaps we even look to the courts, as has been desired by certain parties in the past. But those are the criteria that we have, and those are the rules that everyone's living by. So that is one part of it. The other part of it, as was mentioned earlier, is we do have only 4 groups that are looking at these petitions. There's only $1.9 million. Out of a $2.3 billion budget, we have a lot of other responsibilities, and this has to necessarily receive this $1.9 million because those other responsibilities, as you well know, on this committee involve everything from roads, taking care of land, fire suppression. It's a vast world of trust responsibilities that we take care of with that other $2.5 billion. We have tried to find money when possible to acknowledgement. We've tried to move it up from 4 teams to 5 teams, but it's a small change in the process. You know, and I know there's criticism and of the delays and how long it takes, but this is a two-sided process.
Let me ask you this. Have you thought of submitting a bill, your ideas of a bill to Congress that would expedite, modernize, and bring us into this century on this process?
We have, and been looking when I first came on board. And the reason why I said March 6th is when we first started looking at this is because I came on board on March 5th. And it was around near that time that I sat down with Lee and a little bit later, much of his staff, and asked that very question. What can we do to help change this process? You're on the front lines every day. You're the academics with the expertise. Where do you see potential need? We looked at past hearings and critiques that we've received, and we came up with a great list of things that we can do. And then we divided them into guidelines, regulation, and legislation. So yes, sir, we are developing that potential legislation.
I appreciate that. You know, within the Department of Interior, the Department of Interior's budget is several $1 billion. You have $1.9 million for this. Isn't there some way within the department when you deal with OMB, you say, listen, can't we rearrange some priorities? It seems to me that within the billions of dollars Interior gets that you only get $1.9 million. How zealous are you in telling OMB we need more and shift some things around? Cap Weinberg used to do. He used to slap the OMB around and shift things around within the Department of Defense. You need advocates within the department to set proper priorities. It seems to me when you look at your budget and you find the billions you get in the Department of Interior and only $1.9 million for this, that you have to become greater advocates when you approach the budget process each year. Are there great advocates to, I mean, 1.9, I've made phone calls to get more money than that for an airport in my district.
We are advocates for Indian tribes, sir. And when you look at the $2.3 billion, and the budget has decreased over the years, and this is something that we've recognized within the department. We're actually going out to Indian country. We have, over the last month, gone to Indian country and said, here are the number of issues that we're facing. Here are things that are problems that are creating stresses on the Bureau of Indian Affairs and the Bureau of Indian Education and my office, the Indian Affairs Office. How can we change ourselves as a group in talking to Indian tribes? Not even consultations, but just dialogues, so starting the dialogue of how can we change ourselves to better meet what's coming up ahead. And one of the things that keeps coming back, one of the things we know of, and one of the things we talk about every quarter with the Tribal Budget Advisory Committee is how can we get more money into this process. But when you speak with the Tribal Budget Advisory Committee, probably our main input from Indian country on these budget issues, the priorities that come up are supplying more money for Indian reservation roads, dealing with the fractionation issue. The fractionation issue alone is a multi-billion-dollar issue. That's probably $3 or $4 billion. Then you have the another $3 to $4 billion for water rights settlements. Then we've got the water restoration issues that we have in the upper Midwest and throughout the South and Southeast. Additionally, as everyone here knows, there's been a number put on the Cobell settlement of $7 billion, but there's the $120 billion is still floating around out there. So there are a lot of priorities that are coming our way. And what we have to look at from the Bureau of Indian Affairs perspective, first and foremost, is that trust responsibility. Are we hitting our trust priorities and our trust responsibilities? For better or worse, this doesn't rise to that level yet. This is something that we need to do. This is something that we have the expertise in. But getting that direction from OMB or be it from Congress, that's something that we would appreciate as well. This is something that we consider to be very important. The more money we have to deal with this issue, the quicker that we can dispose of all the ones that are out there, the 17 or the 243 that have incomplete petitions. We can deal with all of those. So this is an important issue, and we have a lot of staff, and we spend a lot of time dedicated to this issue. And in fact, one of the things I did when I came on board was change the organizational chart so that Lee reported directly to me. This is how important I view the issue. But we have to make do with what we have right now.
I appreciate that, but you know, in this issue right here, this is something that is embodied in our Constitution. This is not a peripheral issue. This is something that each one of us up here in the dais take an oath to uphold. This is written out in the Constitution in specific terms. And it seems to me that that should give it a higher priority within the entire Department of Interior when you go to OMB. Send them a copy of the Constitution. Tell them you have some obligation to try to recognize when there's real sovereignty. Thank you very much, Mr.
Thank
Chairman.
you, Mr. Congressman.
Gentleman from Tennessee, Mr. Duncan.
Thank you. Thank you very much, Mr. Chairman. Mr. Artman, we have a briefing paper on this hearing that says under H.R. 2837, the entire pending caseload of more than 200 documented petitions and letters of intent to petition are transferred from the department to the new commission. Also, petitions previously denied by the Secretary would be entitled to an adjudicatory hearing. I'd like to know how many, if you know, how many are in each of those three categories. How many documented petitions do you have pending?
We have 7 that are on the active list. That means they're currently on the desk of one of our teams and being prepared for final determination, 5 of which should actually happen over the next, I think, 6 or 7 months. We have another, I'm sorry?
And how many are on the non-active list?
Well, we have another 10 that are on the ready and waiting for active consideration list. Those will naturally fill in as we deal with the 7 that are on the active list. And then we have 243 not ready for any number of reasons. Either they have only a letter of intent in, or the petition application isn't complete.
So that adds up to, that was 243, and you said?
17, so 260 plus.
All right, and then how many petitions previously denied would be entitled to a new hearing?
Well, let me see. We've had 61 negative decisions since over the past 28 years. So it'd be, I guess, a potential.
So you're talking about 320, basically. Do you have any rough guess as to how many Indians would be involved in those 320 petitions?
No, no, sir, I don't. The populations for all the petitioning groups varies from 3 or 4 all the way up to 50,000.
So the total in the 320 petitions then would be many, many thousands.
I would imagine so, sir.
And how much are we spending at this point on the for the budget for the Bureau of Indian Affairs and the Indian Health Service and all the any and all related Indian programs?
Well, for Indian Affairs, our budget is $2.3 billion. I'm not sure what IHS's budget is. The Department of Education, Department of Transportation, and Housing and Urban Development also receive money as well.
So you don't really have any idea what we're talking about?
Not in those tangential funds, not outside the Department of the Interior.
But at any rate, you would be adding huge amounts of expenditures if all of those 320 petitions were approved.
I think, yes, if all 320 were approved. I think, you know, that's a draconian situation. I mean, of the 61 that were negative, I'm willing to stand behind those and say that there was good reasons for a negative determination. I'm sure that even a commission like this would still probably find the same thing. The 243 in the list, I believe also that, you know, many of those folks sent in a letter of intent, and that's the last we've ever heard from them. We know for a fact that one of the individuals who sent in for a letter of intent was recently arrested in Florida for trying to pass himself off as an Indian tribe. So many of these disappear. And one of the things that we're going to be doing in the next few months is calling that list of 243 and seeing how many real ones are actually out there. And I think you're going to see a substantial amount of those folks fall off as well.
A lot of people have doubts that that you would have this many petitions were it not for the money involved in all of this. But at any rate, I yield back the balance of my time.
Gentleman from, let's see, where? Oh, okay, from American Samoa then. I thought I'd already recognized him.
Thank you, Mr. Chairman. Thank you. Mr. Secretary, you have mentioned, commented about the Department of Justice raising the constitutionality of the proposed bill. Is this basically what you're making reference to?
Of the commission appointment itself, I believe it was.
Yeah, that you're suggesting here that the Congress does not have the authority to set up a commission?
I'm not suggesting it. I only pointed out that the Department of Justice has raised concerns. I'm not sure what those concerns are. I haven't received a full and final briefing from them yet, so I really can't speak to those.
Oh, I'm sorry that the bell is rang here. You know, I don't think there's any blame being put on the bureaucracy or the Department of the Interior. Fact of the matter is that the Congress has simply never acted in setting up a system statutorily as far as the recognition process. So this is the reason why the Department of the Interior set up these regulations, and you came up with these 7-point criteria in order for a tribe to become recognized. So that's simply the reason, and I'm sorry to say it's taken this long for Congress now to propose a bill to mandate statutorily how we're going to go through the process of recognition. You mentioned that you have a $2.3 billion budget, and out of that, $1.9 million is allocated to do the recognition process. Doesn't tell me that there's not much of a priority then in the process, does it?
Well, there are the other priorities that we have. While we would certainly like to have more in the budget, we have what we have, and that's something that we've worked out within the administration and through Congress and that whole process. But we do have the other trust responsibilities that we have to administer.
Mr. Secretary, I understand that fully well, but I'm just simply saying out of a $2.3 billion budget, $1.9 million is allocated for the functionings of the recognition process. What tells me, and I'm not a mathematician, is that there's not much of a priority really given by the department to do the process.
That could be one way of looking at it. I'm sure that the other 562 tribes might say, yes, but we need the money too.
I see. So for some 109 tribes in California and probably some others that have been seeking recognition for how many years now, that's not considered a priority as far as the administration is concerned.
Actually, the 109 that was referenced earlier, 108, there are 108 recognized tribes in California, and to those 108, part of that, they received part of that $2.3 billion budget. I think there in California that there are currently 74 tribes seeking recognition in that area.
Would you agree that the only reason why Congress has not finally taken step on this is simply because there's no legislation been introduced to address the issue of recognition?
I think that, well, certainly. I mean, in many respects, we've filled that void with coming up with the regulations nearly 30 years ago.
How soon do you think the Department of Justice will come out with this legal opinion about the constitutionality of this bill?
I'm not sure, sir. I'd be happy to check with people over there and give
Can you submit that for the record? Because I'm very curious if this is going to be the big obstacle that is going to prevent this legislation from going forward. It's because it's unconstitutional. Is that basically the gist of what I hear?
I believe it's only a portion of the bill that's unconstitutional, that they would view it as unconstitutional. I'm not saying that. I don't know. I haven't seen the full and final report, so I can't make a determination on that. Plus, they would tell me they're the lawyers and I'm not. So.
Oh, I thought you were an attorney.
I am an attorney, but how it goes when you step out of that role.
I see you're now an attorney, but not a lawyer.
Something to that effect.
Okay. Thank you, Mr.
That may be a good thing. I don't know.
Thank you, Mr. Secretary.
Is it okay if you yield? Mr. Artman, I'm sorry, but I want to pursue this a bit more, because the sentence, I'm looking at your sentence, moreover, the Department of Justice has indicated there are constitutional concerns with the appointment of members of the commission. Now, I'm reading through the bill, and I, like Mr. Keedy, carry with me a copy of the Constitution. And I carry it with me when I'm walking around here in the Capitol, and I carry it when I go home. Not particularly because it gives me any particular insight, but it gives me a sense of comfort and reminds me of what I'm supposed to do. And one of the reasons I do it is that I have discovered over time, and it has to do with Native Hawaiians and others, that this is constantly raised. And it's almost a throwaway line. And it's meant to stop us from legislating. Precisely what concerns have been indicated, and how were they indicated to you by the Department of Justice? Do you have a letter? Was it a phone call? Do you have something that you can give us in evidence here to the hearing about what these concerns were and are, and how they were indicated to you?
Congressman, no, I can't. And as I told
why is the
Mr.
testimony
Vega,
here?
that we will get you a letter from the Department of Justice.
I beg your pardon?
I said we'll be happy to arrange for a letter to be sent from the Department of Justice to you on this issue.
No.
I have nothing here today, and I'm not going to.
And why is the sentence in your testimony?
I believe it puts it in very soft terms that there may be an issue with the commission process.
How do you know that?
The Department of Justice has done its initial review.
Where?
I don't have it with me.
So there is something on paper?
I'm sure there is.
No. Not whether you're sure there is. This is testimony. The Department of Justice has indicated there are constitutional concerns. How do you know that?
In conversations with the Department of
So
Justice,
it's a conversation. It's a
made
telephone conversation?
I'm sure there was. The staff put that in there, and I'd be happy, and I will support it.
No, don't fool with me on this.
Did I have a conversation with the Department of Justice on this?
Yes.
Is that the
Did
question?
you?
No, I haven't. I understand.
Who has in your department?
The staff that helped develop this.
So the staff has had conversations. Yes. Who in your staff?
Members from Congressional Affairs, members from the Indian Affairs staff.
Who on your staff has had conversations with the Department of Justice concerning constitutional concerns over this bill?
Mr. Abercrombie, I'll be happy to get those names for you.
So you don't
I'll be happy
know.
to get a letter for you.
Who wrote this testimony?
Various people.
Who put this sentence in the testimony?
I will be happy to find that out for you, sir.
So you're reading testimony you haven't written or vetted? You didn't ask the question.
I did approve it.
Did you ask the question of anybody who gave you the testimony is who has the concerns?
Not of that particular line.
Why did you say it then?
Because if you're looking at it from the legal perspective, again, I'm going to be entering into areas which the lawyers are going to be better prepared to talk about at the Department of Justice. But I imagine this is...
It is a serious accusation. It's not an observation. That legislation would be forthcoming, that we would be so cavalier, or the gentleman from Samoa would be so cavalier as to put forward legislation that hadn't been vetted, at least minimally, about whether it meets constitutional standards. This is constantly brought up in order to try and thwart legislation coming forward. We have constitutional concerns. What constitutional concern? At least, perhaps you can answer this. Can you give me minimally what you mean when you say there's a constitutional concern about the appointment of the commissioners? Because I've got the bill right in front of me. I've read it word by word, and I've reread it right now.
It would be probably a separation of powers issue.
In what context? The bill says that the president should make the appointment.
And then I believe it also says that the Senate should confirm.
Yes.
And there's...
That's what the Constitution says. I got it right in front of me.
Yes, it does, but there are oftentimes commissions where Senate confirmation isn't always necessary.
That's right. And it specifically says in here, it shall not be of the advisory. The commission shall be an independent establishment as defined in Section 104 of Title V, United States Code.
Okay.
Is Section 104, Title V, United States Code now an issue of constitutionality?
I don't think so, sir. But again, this is, we're going to need to get something from the Department of Justice to have a fully vetted debate on this.
You may think that you're being pushed around here. It's not you individually. Believe me, it's not. I'm not trying to do that. It's that we run into this over and over and over again. It is a tactic. I don't know if it amounts to a strategy with the administration right now, but it's certainly some kind of tactic where there's these toss-away lines in everything with respect to whether something's constitutional. It's almost quotidian in the way it's quoted, and appears in testimony. Well, there may be constitutional. What the hell are you talking about? It's not fair. It's not right. I'll tell you something. It's not fair to you. It's not fair to your department for the Department of Justice to casually waltz in with a conversation, nothing in writing, or however the heck it came before you and however it appeared in the testimony here. Believe me, it's not just your department. This is done over and over and over again. And I think it's a disservice to you. It's a disservice to your section of the department. It's a disservice to your testimony here to have this in here. So I would like, and I hope you understand, I'm not personally trying to hold you to, well, in some respects I am, because you've given the testimony, and you have to stand by it. Just, but surely you can see that by virtue of the answers you've had to give, that this is at best vague to the point of being in the ether somewhere. And in terms of specificity, for us to be able to move forward, we need to know what are they talking about and why is it in this testimony? And why are you being subjected to it? Or your portion of the Department of Interior being subjected to this kind of imposition by the Department of Justice as to whether or not you could move forward with opposition or support for this legislation? Okay?
Thank you, Mr. Abercrombie.
Someone's time has expired, or whoever's time it was. The committee will stand in recess pending 3 roll call votes on the House floor. Mr. Secretary, we would appreciate your continued patience, as I believe there are a couple other members yet to ask questions, and they will have that opportunity when we return. Committee's in recess.